Welcome. Today we're discussing a critical and often highly emotional legal issue in Texas. What happens when someone refuses to turn over a deceased person's original will? This is a serious matter, and the law in Texas does not treat the withholding of a will lightly. In fact, non-compliance can lead to severe legal penalties. Losing a loved one is hard enough, but what happens when a family member or other individual is holding the original will, effectively holding the estate planning process hostage? This scenario is covered directly by the Texas Estates Code. In Texas, finders keepers absolutely does not apply to estate planning documents. Refusing to produce a will can lead to court-ordered confinement. We're breaking down the Texas Estates Code and the serious consequences of non-compliance. First, let's look at the affirmative duty imposed by Texas law on anyone holding the will. Under Texas Estates Code Section 252.201, the law is absolutely clear. If you have custody of a deceased person's will, you must deliver it to the proper court clerk. This is non-negotiable. This requirement is a mandatory statutory obligation, not a suggestion or a request. As soon as you are notified of the testator's death, that original document belongs with the court to begin the probate process. So what specific steps can you take if someone refuses to hand over the will? The first step is filing a sworn complaint. You file a written sworn statement with the court alleging that a specific person is hiding or refusing to produce the will. Next, the court issues a citation. This is a formal notice, often called a show cause order, ordering the alleged individual to appear before the court and explain why they haven't produced the document. At the hearing, the person must show good cause for the delay. If they fail to provide a valid legal reason, they will face the judge's ruling and subsequent penalties. Now let's discuss the serious civil repercussions for ignoring a court order to produce the will. Under Estates Code Section 252.203, if the person ignores the court's order without a valid reason, the judge has the power to order their arrest. They can be confined in jail until the will is finally produced. Beyond confinement, the person can be held financially liable for civil damages. They must compensate any heir or beneficiary who suffered financial loss because of the delay in probating the estate. It's important to know that this issue extends beyond civil court. Criminal statutes also apply to tampering with a will. Under the Texas Penal Code, concealing, destroying, or tampering with a will is classified as a state jail felony. Messing with these documents, whether before or after the testator's death, is a serious crime with potential jail time. Finally, are there any exceptions, and what is the key takeaway? There are exceptions if a will was truly lost or accidentally destroyed. Texas law permits probating a copy, but the legal burden of proof is extremely high. You must prove the will was not intentionally revoked by the deceased. Bottom line, if you have the will, turn it in immediately. If someone else has it and refuses, consult with a probate attorney to begin the sworn complaint process without delay. The law is designed to help you secure the document.